morning, good afternoon, everyone. Thank you so much for joining us today on another session of the We Connect Academy Learning from Women Leaders Around the World series. My name is Andrea, and today I am very happy to introduce Brittany Miller, who is an associate at Walker Law Professional Corporation, a women business enterprise certified in Canada. Her practice focuses on commercial and civil litigation. Brittany regularly appears in the Small Claims Court and the Superior Court of Justice in Ontario. She received her Juris Doctor from Osgoode Hall Law School in 2017. And prior to law school, Brittany attended the University of Western Ontario, where she received an honors specialization in political science in 2014. Walker Law Professional Corporation is a boutique commercial litigation firm in downtown Toronto, Ontario. They specialize in property, employment, and business law. Today, they will tell us more about legal processes at work, ways to prevent and resolve conflicts in your business relationships, very important for all the WBEs who are listening to us today, best practices in forming contracts, and she will also explain a little bit about the importance of good business practices, especially when negotiating or forming contracts, which can help you avoid legal issues in the future. I'll let Brittany introduce herself, but I would like to remind all the attendees that you are muted, and if you have any questions, please write them down in the chat or Q&A boxes. I will read them out loud at the end of the webinar. This is a one chance opportunity to learn as much as we can from Brittany, so I encourage you to do as many questions as possible from the very beginning. At the end, she will be sharing the information of her contact information, and we'll be answering all these questions. Thank you, Brittany, for being with us today.
Hi, everyone. Welcome, and thank you so much for tuning into my webinar. Andrea gave a pretty good summary of myself, but just a little bit of additional information about myself. I'm a lawyer practicing in Toronto and Southern Ontario mainly. As Andrea mentioned, our firm, Walker Law Professional Corporation, focuses on commercial litigation. So what that means is we represent individuals and corporations in lawsuits, both in and out of court. And we have clients who range from individuals to small businesses to Fortune 500 companies. So we understand that all of these different groups of people have very different needs. So my presentation today is preventing and resolving conflicts in your business relationships. So broadly speaking, it's about best practices in forming contracts, how to settle contractual disputes outside of court, when to sue, and how to navigate the court process. So my presentation will mainly be focused around Canadian and Ontario law, but it has a general application to wherever you may be. The processes are likely somewhat similar. And as Andrea mentioned, feel free to ask questions. I'm happy to answer all of your questions at the end of the presentation. I also just want to mention everything in this is not intended to be independent legal advice. Of course, if you have a legal question, it's essential that you consult with your lawyer, but this should be good information about legal topics that can help you in your businesses in the future. So my presentation is going to be broken down roughly into 4 sections. So first, I'm going to cover some good business practices that you can hopefully employ now. Then I'm going to talk about settling your disputes without pursuing litigation, which is always the ideal. Then I'd like to discuss some things you should consider when determining whether you can and should sue. And finally, I'll give you a brief introduction to the court process and what that looks like, so you can have an idea of what to expect if you do become involved in litigation. And something to remember is a lawyer can help you with any or all of these things, and often you're better off consulting a lawyer earlier on rather than waiting until you're in court to seek legal advice, because litigation is really a last resort. Litigation can destroy your business relationships, it can cost you customers, and it can devour hundreds and thousands of dollars in legal fees and years of your life in time and stress. So when everything else has failed, that's when you should consider litigation, but only if there's something worth saving. It's really more efficient to avoid litigation through good business practices. So as a commercial litigation lawyer, most of the cases we deal with are based on breaches of contract. If you do end up in litigation, the key issues that a judge is going to look at are, was there a contract? How should the contract be understood? What did each party promise to do? Was the contract breached or violated? Did one party not uphold their end of the agreement? And what amount of money should be awarded to compensate the victim for the breach of contract? So a very simple example of this would be, suppose you own a clothing store and you sign a contract to buy clothes from a manufacturer who is responsible for sending you a shipment of clothes each week. So 1 week, the manufacturer is late with one of his shipments, and as a result, you run short of merchandise and you lose sales. So in this sort of circumstance, the manufacturer has breached the contract, and you have the option of suing for the profits that you lost because of these lost sales. However, what you would be expected to do is try and limit your losses. So for instance, try and acquire the merchandise from another supplier to make up for the shortfall from that manufacturer. This is really just to say, you end up in litigation on these types of contractual issues. The judge is going to take it into account to see whether you've just sat on your hands and done nothing or tried to mitigate your losses. And if you do decide to do nothing, you might not be able to be fully compensated. So one thing people often wonder is, do you always need a written contract? And the answer is, of course not. But if you don't have it in writing, you will likely run into two kind of major problems. So the first problem you're likely to have is that you and the other party might each think the agreement was for something completely different. If you're not on the same page when you're drafting the contract, it's likely you're going to disagree later on about whether you've each done what you were promised to do. The other problem that kind of stems from the first is that if the other party doesn't uphold their end of the bargain, for instance, if they don't pay you, it's going to be very difficult for you to take them to court. If the agreement isn't in writing, it's going to be hard to enforce, and it may even be hard to prove that there was ever an agreement at all. That being said, it is possible to enforce an unwritten agreement in court, or a verbal agreement. However, as I mentioned, it will probably be very difficult and it will likely be very expensive. So the things you would need to prove if you don't have a written contract are that you and the other party had an agreement in the first place, what the terms of the contract were, and that you both understood the agreement to be for the same thing. Naturally, you'll have to prove that there was a breach of that agreement. And as mentioned earlier, you need to prove the amount of money that should be awarded to compensate you for the breach of the agreement. Likely, if you don't have a written contract, you might need to call witnesses, or you yourself might need to be a witness to try and prove what the contract said. The problem with this is, if you have a trial several years after this handshake agreement took place, your witnesses' memories might be wildly divergent. You might not have the best recollection of what was actually agreed to. Often we have cases where you call a witness to corroborate something in an agreement, and by no intention or fault of their own, they end up contradicting themselves, or their minds change between the beginning and the end of the litigation. So really, all this is to say, if you are entering a contract, it's essential that you get it in writing. So this should be less of an issue for you in your dealings with larger corporations, but if you're a small business doing business with a large business, they probably have a contract that they want you to sign. Regardless, you need to read the contract, have your lawyer look at it, just so you understand what the contract says. So I want to step back for one moment and just discuss what a contract is. So put very simply, a contract is 1, an agreement, and 2, it's for an exchange of value. So value can be goods, services, money, a promise to do something if certain conditions are met, or it can be something else. But this is what's called consideration. And the contract should be specific about what consideration each party is giving to the other. If either party doesn't give something of value, so if they haven't provided consideration to the other party, then you might not have a contract. People often ask, how little value can a contract be for? So the answer to that is really, there isn't a formal minimum, and the worth of the things exchanged in the contract doesn't have to be equal, but both parties have to give something of value. So in one case, The case you'll see up on this slide, one party promised that in exchange for something of value, they would consider entering into a long-term business relationship with the other. The court in this case described this promise to consider, which was that party's consideration, as having only fanciful value, and said that there was no contract at all. So this isn't to say that the consideration that is provided has to be substantial, it just has to be something of value. And in that case, a promise to consider to do business with someone was not found to be valuable enough. So sometimes there are situations where parties may want to contract and one party really seems to get all of the benefits under the contract. So as we discussed, there needs to be consideration and there also needs to be offer and acceptance. So someone has to make the offer to contract and you have to accept it. So in these situations where one party seems to get all of the benefits and the other one's just kind of giving something nominal, in law they call this the Peppercorn Theory. So this applies where you want to have a contract where one party gets most of the benefits and you're both okay with that, but you still want your contract to be binding and to be enforceable. So in this situation, it's very crucial that your contract be drafted in a very particular way to make sure that you can still enforce it. And it needs to be written so that this token sum, which might be the exchange of $1 or one peppercorn, as the story goes, is still binding. So the key here is that the value given by each party doesn't have to be equal, but if it's very unequal, you might run into issues if the contract isn't carefully drafted. Something else to keep in mind here, particularly if you're being asked to sign a contract you didn't write, is that you can't contract out of many statutory rights. So an example of this would be anti-discrimination rights under a Human Rights Code, employee rights under an Employment Standards Act, these things that are set out in statutes that have to be provided. You can't contract out of many of those things, and even if you try to in your contract, it's likely that the court will not enforce it. However, there are also some things that you can contract out of, such as your right to criticize someone publicly, or you can even contract out of your right to sue in some circumstances. The other things courts will not enforce as a part of a contract are if the contract requires something illegal. This may seem like very common sense, but sometimes people still run into situations where they've included something illegal in their contract. So in these situations, the courts might just strike out that portion of the contract entirely, or they might try to modify it to make it legal. So an example of this would be, there's a case in Canada where two companies, through a miscalculation, entered into a contract where one would pay the other a criminally high rate of interest. And in that case, the court determined that the best resolution would be to reduce the amount of interest to the highest legal rate and enforce the contract. So these are things to keep in mind when you're drafting a contract. Sometimes the court might strike it out, sometimes the court will use their discretion and make the contract valid. So if you're the one drafting the contract, one of the benefits is you can put it down in writing and it really gives you time to think through what the agreement will look like and how the agreement will operate. So you have the opportunity here when you're drafting the contract to short-circuit some high conflict problems before they even start. So here's an example of some things you should consider if you are drafting a contract. What are the conditions that must be true before you or the other party can fulfill the contract? This could be any number of things. For example, it could be the other party needs to have certain financing in place. That's a condition that would have to be fulfilled. You should also consider what are some things that might go wrong and what happens if they do. What if someone fails to uphold their end of the bargain? What happens then? And what if someone wants to end the relationship early? Is there a mechanism for them to do that? Or is that not an option under your contract? Putting these things in your contract and agreeing on what to do about them ahead of time can help prevent these events from leading to litigation when they do arise. But if you're presented with a contract that's already drafted, as you would be if you might be dealing with a large corporation or a government procurement office, there will likely be clauses that are already present to address these questions. So what you need to do then is consider if the whole agreement works for you, because the other side may not be open to rewriting the contract. But at the very least, you need to know what you're agreeing to and what your rights and obligations are under the agreement. And again, show your contract to your lawyer, because they can help you understand everything in the contract and what these clauses really mean. So this case, I'm about to tell you about an example of why it's important to know what a contract is for and how a lack of specificity in the contract can lead to conflict in business relationships. So in this scenario, you have a contract to supply chickens to another business. All the contract says is chicken, and that the other party will agree to pay a certain price for it. So what are you supplying? Are the chickens alive or dead? Are they whole or in parts? Skinless, boneless, cooked, raw? What's the quality of the chicken? The contract doesn't say. So in this case, in 1960 in New York, two companies entered into a court battle to resolve exactly the question of what chicken meant. So the supplier had provided an older, cheaper chicken that they called stewing chicken, and the buyer told the court that they actually wanted young chicken suitable for broiling and frying. So in this case, the court said that the party who was contracting for the supply of the chicken should have been more specific about what they wanted. So obviously, you can see some conflicts are inevitable in contracts, but in this case, if the contract had been more specific, these parties could have avoided this very expensive litigation. So there are a few clauses that you should consider putting in a contract if you're drafting it or reviewing if you are the recipient of a contract. And three that I'm going to focus on are severability, an entire agreement clause, and a choice of law clause. So I'm going to go through each of these different types of clauses one by one. So the first is severability. And what this means is that you're agreeing that if part of your contract is found to be illegal or unenforceable, the rest of your contract will still remain valid and enforceable. And this is a good clause to have because you don't want the fact, if you run into that situation where one of your clauses is illegal inadvertently, you don't want that to mean your whole contract is essentially gone. So what I have on the slide here is an example of a strong severability clause. You can read it and I'll read it out for you. It says, if any provision of this agreement shall be determined to be invalid or unenforceable, either in whole or in part, this agreement shall be deemed amended to delete or modify as necessary the invalid or unenforceable provision or portion thereof, in order to render valid and enforceable all remaining provisions of the agreement. Such remaining provisions shall be fully severable, and this agreement shall be construed and enforced as if such invalid or unenforceable provision had never been inserted in this agreement. So, depending on the contract, if you run into litigation, the court may do this anyway, because they might not see the utility of rendering your whole contract unenforceable, but it's a good thing to have in your contract just to protect yourself. So the second is what's called an entire agreement clause. This means that you're agreeing that the written contract that you have drafted or you may have received from the other party is the entire agreement. There aren't any other parts of the agreement that are written or oral or scribbled on a napkin somewhere. The written contract is going to replace any other prior agreements you might have had and any other promises or representations or discussions you may have had before signing the contract. Of course, if you enter into an oral agreement after signing the written contract, or if you sign the contract without knowing this clause was in there, or there was some sort of fraud, then those may be situations where this clause isn't enforceable. But again, read your contract, and if you're drafting it, make sure you have this in the contract if you want this one document to contain your entire agreement. So I've included an example of the entire agreement clause here. It says, this agreement constitutes the entire agreement and understanding of the parties with respect to its subject matter. Each of the parties acknowledges that in entering into this agreement, it has not relied on any oral or written representation, warranty, or other assurance, except as provided for or referred to in this agreement, and waives all rights and remedies which might otherwise be available to it in respect thereof, except that nothing in this agreement will limit or exclude any liability of a party for fraud. These clauses are very wordy, they're very much in legalese, but the purpose is to understand that this is saying this agreement contains everything that we are agreeing to, and there's nothing else outside of it. So the last one I wanted to bring to your attention is what's called a choice of law clause. So this means that you and the other party are going to agree which province or state or country's laws should be used when interpreting your contract. So if possible, we would usually recommend that you use the law of whichever province or state or country you and your lawyer are operating in. So if you're in Halifax and your lawyer's in Halifax, the easiest option is for you to use Nova Scotia law. If you're in Chicago and your lawyer's in Chicago, use Illinois law. Obviously, you may run into situations where the other party is located elsewhere and they want the contract to be interpreted under, New York law or Delaware law. In those circumstances, the best thing to do would be to consult a lawyer with experience in that jurisdiction just to make sure the agreement can be interpreted correctly and that you're fully protected. So you see an example on the slide here. It says this agreement will be governed by and interpreted in accordance with the laws of the province of Ontario, Canada, and the federal laws of Canada applicable herein, excluding any conflict of laws rules. So this is just a helpful clause to have because there are certain situations that it might be a bit ambiguous what law should be used to interpret the contract, so this removes that ambiguity. So once you have a contract, there is still the risk that the other party perhaps doesn't pay you what you owe. We always recommend when a client comes to us with a contractual issue, or with most issues, that settlement is kind of the first thing you should think about. Is it possible to settle this dispute without going to court? One common question we have kind of at the outset of this settlement discussion for corporate clients is whether they have any tips to collect receivables more efficiently to avoid this kind of situation of non-payment. So I have a few suggestions for you on this next slide. So first, pretty basic, get something up front like a deposit. This is going to mean you at least have something that you can collect from. We also recommend, as a good idea if possible, depending on the structure of your relationship, try and get credit card information and written consent to bill their card for the remainder of the payment on a specific date. So there might be a way to set this up with a larger customer. The point is, you really want to try and make payment as automatic as possible, so you're not trying to chase people down for payment. The other thing you should do is be prepared in case the person doesn't pay. For an individual or small business, this might mean trying to get as much information as possible about the other party's assets. So, bank account information, employers, any assets they have. This is important in case you do need to take someone to court and seize their assets or income to satisfy your judgment. The reason we raise this is because if you sue someone and you win, the court isn't going to help you collect your money. It's really just a piece of paper. So if you know an individual or business's bank account information, you might be able to get an order from the court to have some money from that account garnished and paid to you. If it's a person, if you know their employer, you can get an order for the employer to withhold a percentage of that person's wages and pay that money to you. Or if you know of some assets they have, like property, you can get an order to put a lien on the property. So how you do this really depends on what type of person or other party you're dealing with, but it's a good idea to think about these things if you have any concerns about collecting receivables. And generally, this is less of a concern for government entities or large public corporations since their assets are easier to find. But even so, there are some mid-sized businesses that are very good at hiding their assets or shifting them around to make collecting on debts difficult. So if you're dealing with a smaller or more mid-sized business and you're concerned the business doesn't have any assets, or you can't tell the difference really between the business and the business person, ask the person you're dealing with if they are the director or the sole proprietor of the business to provide a personal guarantee for the business's debt to you. You can put this in your contract and say, if the business doesn't pay me, the person will pay me instead. Of course, if you're a small business and you're dealing with larger businesses, they might ask the same thing as you. So you should be prepared to consider whether that's a risk that you want to take in your contractual relationships as well. So I've told you a bit about preventing conflicts with good contracts and how to collect receivables. But, I mean, things can go wrong anyway. Even if you have the most perfectly drafted contract, unexpected things can happen, conditions can change, people sometimes simply can't pay what they owe or do what they promise. So now I want to talk a little bit about your options for avoiding litigation. Often, litigation will end a business relationship for good. So you should see this opportunity as trying to preserve a potentially valuable business relationship. So as I said earlier, litigation is a last resort. It's expensive, it's going to destroy the relationship with the other party, so you should really try to negotiate first. There's this classic book called Getting to Yes. Some of you may have read it. This book suggests, among other things, you should need to take a realistic view of your best alternative to a negotiated settlement. So if you can't settle this issue, what's the next best thing that can happen to you? If your best plan B is taking your business elsewhere and it's cheap to do so, then maybe your next best option is to break off the relationship. And if you get in a dispute with a large company, this might be what they do to you if you don't settle. So if the cost of breaking off the relationship is too big to swallow, even one bad deal might be cheap by comparison. You also need to consider the other party's best alternative to negotiated settlement. Again, if you're dealing with a large corporation, they might not have any problem with simply dropping you as a supplier. So at this negotiation stage, it's important to consider, if you can't negotiate, what should you do next? Should you just walk away, or should you consider litigation? If you are able to come to a settlement, which is the best case scenario, you will want to formalize your settlement into a written contract or a settlement agreement. Keep in mind, you need to get this in writing, since this is another contract. You need to specify what the exchange is. Is someone paying someone else money? Is there some other sort of exchange that will occur? And you need to put in what the conditions are. You will also likely want to agree not to litigate. So often in settlement agreements, you'll see a clause that says, both parties will agree not to start any other lawsuit action, et cetera, that has anything to do with this particular issue. Both parties should also agree to maintain confidentiality, both about the settlement agreement and the dispute leading up to the settlement, and agree not to disparage each other publicly. Obviously, the last thing you want once you've settled a heated dispute is for someone to go and write a scathing post on Facebook or a review of your company somewhere, so it's important to have this type of clause in there. And these clauses will likely also be very important to a larger company whose public brand image is very important to them. So let's say you've tried to settle, you've done everything you can to negotiate, but the other side is just not being reasonable, or maybe they owe you a really substantial amount of money and you just can't walk away from that. The next question you need to ask yourself is, can you and should you sue? It's important to consider whether there are any issues that might actually prevent you or discourage you from suing. So the first thing you need to look at, if you have an agreement, is whether the agreement allows you to sue. So particularly if you're doing business with a large corporation, some contracts will actually state that any dispute must be dealt with through mediation or arbitration before or instead of going to court. So the difference between mediation and arbitration is a mediator can only encourage you to settle. They'll try and negotiate with you and suggest possible compromises, but they can't impose any particular solution on you. Whereas an arbitrator actually has the power to impose his or her decision on the parties, and it's binding whether the parties like it or not. Another issue that you should consider if you're thinking about suing is the limitation period. So this means, did you wait too long to sue? both the law in your particular jurisdiction and any agreement you have might actually limit how long you can wait after the event to sue. So in Ontario, for example, you generally have to start your lawsuit within 2 years of having discovered whatever problem you're suing over. So, for instance, you would have to start your lawsuit 2 years after you discovered that someone didn't pay you money that they owed you. If you don't start your lawsuit within those 2 years, you are probably out of luck. Another thing you need to consider is jurisdiction, which I mentioned a little bit earlier. So, does the contract specify the jurisdiction that you have to sue in, or perhaps you need to sue in a particular jurisdiction because that's where the harm took place? Another thing to consider that's very important is whether you have enough evidence to win a lawsuit. If you're suing, you need to prove that the other side has done something wrong to you and that you've suffered a specific amount of damages as a result. Often, our clients and litigants in general are very, very surprised about how much it takes to convince a judge of both of these things. You need evidence. This can be documents, it could be a contract, letters, emails, text messages, it could be the testimony of other witnesses, but you need to have evidence to back up every point in your story. And another thing to consider, as I mentioned earlier, is witnesses, depending on the amount of time that has passed, can be much less reliable than documents. Documents don't suddenly misremember something the day of trial. A witness might. So if you haven't gotten everything in writing and you haven't kept very good records of your business dealings, you might not have enough hard evidence to convince the court that what you're saying is true. And you need to consider that before you spend a lot of money on litigation. Another important question that I've touched on a little bit is, if you're going to sue someone for an unpaid debt, will you actually be able to collect the money once you get the judgment? If you sue someone and win and they still don't pay you, you're really no better off than before, and you may be worse off because you'll have spent the time and money necessary to go to court, and all you really have at that point is a piece of paper. So it's really your responsibility to collect money if a judge rules in your favor. As I mentioned, you can collect money in a variety of ways, but if your opponent really has no property, no assets, no income, a lawsuit is likely to be a waste of your time. Lastly, what you should consider is whether you can afford litigation. As I said, litigation is very expensive, and if you lose, something you need to consider is that you might have to pay the other side's legal fees as well as your own legal fees. In a case a few years ago, actually, a man sued the CBC in Canada and lost, and in addition to what he owed his own lawyers, he had to pay $1.6 million to cover the other side's legal expenses. So what I'm saying here is don't plan on financing your lawsuit by winning and hopefully having the other side pay your legal costs. There's no guarantee you win. Even if you feel like you have the strongest case, you never know what judge you'll get, what that judge might think of your evidence, and there's no guarantee the court will even award you costs if you do win. And even if you win and you get costs, the other side might not have the money to pay you. You should also know that most lawyers don't take commercial matters on contingency. If you go to a lawyer for a commercial, contractual type of dispute, it's very unlikely that they'll say, give me a portion of your winnings. They will probably ask you for money up front. So you need to be able to fund litigation as it's going on and not just rely on hopefully receiving money at the end. The important point here is really don't rush into litigation. There's a lot to think about before you start a lawsuit. And if you've considered all of these points and you're still not sure how to proceed, the best thing you can do is talk to a lawyer. Don't rush into stressful and time-consuming and expensive litigation if you're really not sure if it's right for you. So if you think about all of those things and you decide you want to start a lawsuit and it is a good idea for you to sue this other party, there are some initial things that you will need to decide. So first of all, you need to find out and decide where you're suing this person. As I mentioned before, it might be in your contract, or it might be based on the jurisdiction that you're in. You may also need to determine what level of court you're suing the person in. So this portion I'm going to talk more about Ontario, but again, consult your lawyer in your jurisdiction and they can tell you kind of how the intricacies of your particular court system works. So in Ontario, you might need to decide whether you're suing in provincial court or federal court. So for most contracts, in most situations where someone owes you money, this will probably be provincial court, which is the Superior Court of Justice. For some specialized areas of law like copyright or patent infringement, you may have to go to federal court, which deals with those types of things. But even within Superior Court, which is provincial court, you have a variety of options for what type of court you can use. It's generally dependent on the amount of money you're saying you're owed. So to give you an idea of that, I'll quickly review how it is set up in Ontario. So small claims court, it's, I guess, the lowest level of court in Ontario. It's for cases where you're seeking money and the amount of money is $25,000 or less. The small claims court cases are faster, cheaper, they're less complicated, and you can be represented by a paralegal. You can also represent yourself, which we generally don't recommend, but you can do it. And cases in small claims court normally progress to trial within a year of starting. So it takes less time and it costs less money, but the amount of money you're seeking is also less. If you're not at small claims court, you will be at Superior Court, either under simplified rules or regular rules. So simplified procedure is for claims of money that are between $25,000 up to a maximum of $100,000. If you're claiming more than $100,000, you'll be under regular rules. And really the main difference here, it's purely procedural. Simplified procedure, there are a few less steps you have to take. The steps move along a little bit faster, but it is still quite similar. And again, remember this is just in Ontario. Your state or province is likely to be a little bit different, and sometimes there are even different rules depending on the particular area you're in. For example, here in Toronto, we have specialized courts for commercial matters known as the commercial list. We have a construction lien court. So it's very important to consult your lawyer and make sure they're experienced in the court that you're looking to start your lawsuit in. You also have options aside from going to court. So you and the other party can use a mediator, or you can go before an arbitrator. As I mentioned before, the mediator can help you resolve your differences. They'll try and help you come to a mutually agreeable solution. They're not going to tell you what that is, but they'll try and help you go back and forth with the other party and see if there's something that's agreeable to both of you that will resolve your differences. Again, with an arbitrator, you both present your case to the arbitrator and they'll make a binding decision. It's kind of more similar to going to court, but more informal, kind of quasi-judicial role. In both of these methods, including hiring the mediator or the arbitrator, renting the meeting room, you and the other party are going to bear those costs up front. However, both can be faster and cheaper than a trial, which can last years. Some legal disputes can also be resolved before administrative tribunals, but this is pretty unlikely in a commercial dispute if it's payment of money or fulfillment of a contract. Most administrative tribunals deal more with human rights issues, employment issues, that type of thing. So if you're the one being sued, your lawsuit's going to start with a statement of claim. And if you receive a statement of claim in Ontario, you will have 20 days to respond. The timeline is probably similar in other provinces, but again, something you should check. So once you get the statement of claim, you also have the option of starting your own lawsuit against the person suing you, which is called a counterclaim. You can also start a lawsuit against other people who aren't involved in the claim at that point, who you believe might be responsible. This is called a third-party claim. There are also a few other types of claims that you can start depending on what happened in your particular situation. However, if you receive a statement of claim and you don't respond within those 20 days, the other party that's suing you can go to court and ask the judge to make a finding that you have admitted everything in the claim and then hold you accountable based on that. So if you are ever served with a lawsuit, it's very, very important that you address it immediately. So, in this situation, it makes sense to sue, or maybe it wasn't your decision and you were sued. This slide will give you an idea of kind of the steps that will happen next. So first, as I mentioned, there's a statement of claim and then a statement of defense. Those are the pleadings. There's also an option to reply to a statement of defense, but it's not mandatory, again, in Ontario. So once you've exchanged your pleadings, the next step is what's known as discovery. So in discovery, there's two aspects. One aspect is the exchange of documents and records, and the other aspect is examination of individuals and witnesses. So this means that the other party will get the witness in a room and they'll ask them questions about the case. You'll have the same opportunity with their witnesses. During this process, if you're a witness or anyone else, you have to answer questions posed by the other party. Transcripts will be prepared, and any inconsistencies that come up during discoveries will likely be brought up during trial. This is the point that I was making earlier, is witnesses are tough because sometimes your memory fails you, sometimes you say one thing and it's interpreted in a different way. So it's very stressful to go through. The next step is mediation. So in Ontario, sometimes courts will require you to make another attempt at settlement. Some jurisdictions specifically require mediation. So Toronto, for example, the court rules say you have to participate in mediation if you want to be able to move on to trial. The courts really set this up so you can settle. Hopefully you will settle. That is the best case scenario for most of these cases. Many situations do not need to actually go all the way to trial. So your next step will likely be mediation. Not all jurisdictions require it though. Another step that may be required is a pretrial settlement conference. So the difference between mediation and the pretrial settlement conference is mediation is with a third-party mediator. They're not a judge. They might have been a lawyer at one point, but they're not imposing anything on you. And as I said, they're not a judge. The pretrial settlement conference would likely be with a judge. So the judge will look at your case. They might give you some feedback on what they think your strengths and weaknesses are, and then the judge will act as a mediator and try and help you and the other party come to a resolution. So the next step after that is trial. Before trial, you want to make sure any relevant documents that you want to rely on at court are given to the other side, and there are court rules that set out how you do this. But this is very important because if you don't comply with these rules and you don't give the other side all of the documents that you want to rely on, you might not be able to use them at trial. It's very important to comply with particular rules on providing documents. You also want to make sure all of your witnesses are going to be present at trial. If you have a witness and you're not convinced that they'll attend, what you can do is provide them a summons and attendance money to get them to trial. So, as I said, most cases will settle before trial, but if you don't settle, this is kind of a rough breakdown of what would happen at trial. So, opening statements would happen first. This means both parties will have the opportunity to summarize the facts of their case. Generally, the person suing, known as the plaintiff, will go first, and then the defendant will go next. After that, both parties will have the opportunity to question each other's witnesses, and during the trial, there might be documents that you want to submit. They'll be identified by the witnesses who will explain to the judge the meaning of the document and how they're relevant. You might also have expert witnesses if there's an issue that's particularly complex and requires some professional expertise to explain, and there are specific rules that govern how you can use your expert witnesses and what's required of them. And then at the end of all of this, both sides will have the opportunity to summarize their evidence and make legal arguments. After that, you have the decision. The judge might provide you with their decision right away, or they might do what's called reserving their decision and send it to you later. And sometimes when a judge reserves their decision, it might be months before you actually receive it. The judge might also require a separate hearing with a separate decision to deal with the issue of cost. So generally, as a kind of rule, the successful party is usually entitled to some costs. Not always. The judge has the discretion to not award any costs, but often costs are dealt with separately from the main issues of the trial. So you might have to attend another hearing to deal with costs. And as I discussed, if you are successful and you get a ruling in your favor, you still need to figure out how to get the other side to pay you. This is where enforcing judgment comes in. So I've already gone over a few options for this. I don't want to repeat myself, but just realize that even once the trial is over, you will likely not have your money that day. So this is a very basic overview of the process. It's different in each province, in each state, and even at each courthouse sometimes. The court might surprise you. They could order mediation in the middle of your trial. You might have to drop everything for a motion in the middle of your trial. This is to say that litigation is not predictable, and you kind of have to be ready for anything. But regardless of what happens, it's never too late to try to settle. So at what point in this process should you start talking to a lawyer? The answer is always as soon as possible. Lawyers can help you draft your contract and advise on how to obtain receivables. They can help you negotiate resolutions to conflicts without having to litigate. As you can see, legal disputes are stressful, they're complicated, even if you don't have to go to trial. So you can hire a lawyer even just to handle communications with the other side. You can focus on things that are more productive, like running your business, and you have the security of knowing that your lawyer is protecting your legal rights. Lawyers can also help you determine whether litigation is a good idea in your situation. You know, when clients bring us a problem, we've often dealt with something similar in the past. So knowing this, your lawyer can give you a realistic evaluation of your chances for success. They can tell you what your problems might be, so you can make an educated decision about whether litigation is right for you. And of course, lawyers can litigate for you. They can represent you in court. I would never recommend running a court case on your own. It is very complicated. So regardless, the sooner you get legal advice, the better. If you call your lawyer after a judge has already made a decision against you, the game is basically over. There's very little they can do for you at that point. So what you should do is, when you're drafting a contract, have your lawyer review it. Anytime something comes up that you have a question about, it's better to ask when your question arises rather than, kind of forgetting about it and hoping for the best in the future. So that concludes my presentation, and I understand some of you might have some questions. So thank you all for your attention, and I will turn it over to Andrea to see if any of you have any questions.
Thank you so much, Brittany. That is very interesting and so important. I think, let me see if we have any questions. If any of our attendees would like to ask anything to Brittany, this is your opportunity. Please write your questions down on the Q&A box.
And just while we're waiting, if anyone has any questions that they don't think of now, my contact information is at the bottom corner of this slide. You can feel free to send me an email if you think of something after the presentation and you want some feedback.
Great, thank you, Brittany. Yeah, if you have any follow-up questions, feel free to email Brittany or us, and we can connect you with her. That was a very helpful presentation. Thank you so much. I believe, well, we have attendees from different places of the world, but I believe most of the content applies for many of the countries. I don't know, what do you think there are any differences that they should have in mind if they are encountering a problem, for example, in a region like Latin America or Asia? Can you mention anything that they should have in mind if they encounter any of those situations that you mentioned, the examples?
I mean, I think the best thing that you can do, regardless of what country you're in, is be proactive with contracts. And, whether it's your first contract or, doing it and you've gotten one from a different party, a different corporation, it's easier to solve problems at the beginning than solve them at the end. And, sometimes when you're reading through these documents, they're so dense that your eyes kind of glaze over. So it's always better to have someone take a second look just make sure you're not missing anything. And I really think that applies regardless of where you are.
All right, thank you. Okay, if anybody, if there's no questions, we can wrap up. Thank you so much, Brittany. I'm sure that there might be any other comments or questions afterwards. I hope you connect with Brittany if you have any follow-up questions. We will, this webinar has been recorded for all the attendees that registered but couldn't join. And also we will be sharing so we will be sharing a YouTube link with you, Brittany, as well, so you can see your webinar afterwards. And yeah, we will send a follow-up email with all our registered attendees. Thank you so much for your time and all the knowledge that you have shared with us today. We will stay in touch, and please do not hesitate to follow up with me in case you have any comments or questions. Thank you so much, Brittany.
Thank you for having me.
Have a good day.